The Constitution, Lecture 8. At this point, we have covered the general powers of the federal government. We've talked about the three branches of government in Articles 1, 2, and 3. We now move on to Article 4, which has to do with the states. And here I want to remind you again of the principle of federalism. So in the United States, the states existed before the Union. Right. Upon independence, each of the former colonies became independent states. They adopted their own constitutions and their own forms of government, at which point they were their own state. And the federal government that's created by the Constitution is not meant to replace the states or to absorb the states or even to fully subordinate the states, but it is rather a second layer of government above the states that's primarily responsible for taking care of tasks that the states individually are either cannot do or cannot do well. So cases where national uniformity is required, or when it comes to also things like regulating relations among the states. Now, federalism in particular is a principle that states that the lower level of government has guaranteed existence. So what that means in the case of the United States is where the federal government is the highest level of government and the states are the lower level of government, the states are not conceived of as being under the control of the federal government. The states cannot be unmade, divided up, merged together, or any such thing by the federal government. Rather, the states have their own guaranteed existence. That's what federalism means. And we've already seen in the earlier articles elements of the Constitution which reflect the federal character of the country. The fact that it's not just one big political community, it's actually a union of several smaller political communities. And so that's reflected, for example, in the fact that all states are equal in the Senate. So that's very much a federalist measure. So what that means is for any bill to become a law, it has to get the support not only of the representatives of the majority of the American people in the House, but that same bill has to meet with the approval of the representatives of the majority of the states in the Senate. And that way, the states are treated as, constituent members of the Union, and especially small states are given more power to influence policy. If everything were done by simple national majority vote, then a lot of smaller states would immediately become totally irrelevant because they would be so small they would have no real influence. So the equality in the Senate is a federalist measure. The fact that originally senators were chosen by their state legislatures was also a federalist measure. So remember, under the original Constitution, and until the Constitution was amended in the 19-teens, the senators were chosen not by voters, but were chosen by the legislatures of the state they represent. So the Illinois state legislature would choose who Illinois senators would be. The Virginia state legislature would choose who Virginia's senators would be. And this was the direct inspiration for this was the fact that, usually how politicians conceive their interests and determine what they will do is partly based on what they think they need to do to please their constituents, right? Because in an elective office, if, as most politicians are, you want to stay in office, then you need to make sure that the things that you do in office are pleasing to the people who have the power to remove you, so that they'll want to keep you instead of removing you. So in the case of the House, what that means is that members of the House of Representatives want to do things in the House of Representatives that were popular with the people of their district. In the case of the Senate, since senators are accountable to state legislatures, what that means is that senators, as they deliberate and vote in Congress, will be especially attentive to the interests of their states. And this was seen as a particular safeguard because it meant that, for example, the founders expected that the Senate would be the one that would be least likely to want to try to take power away from the states, to somehow subordinate the states to the federal government or weaken their powers. Because if you're a senator and you want to stay in office, the last thing you're going to do is pass a bunch of legislation that harms the very people who have the power to remove you. right? Like, let's say you pass a bunch of laws stripping powers away from the states, and then you go back to the state legislature after 6 years, and you say, hey, reelect me to the Senate. Your state legislature is going to say, there's no way we're sending you back to the Senate. We sent you to the Senate, and you did all sorts of stuff to take things away from us. We're not going to do that. We're going to send somebody to the Senate that's going to do what is acceptable to us. So by having senators be accountable to state legislatures, it was assumed that senators would be very vigilant in defending the powers and the prerogatives of the states. So that's also a Federalist measure. Another thing, which I can mention now, is that equal representation in the Senate is the one thing in the Constitution at this point that cannot be amended. Article 5 says you cannot amend the Constitution to make Senate representation unequal. The only way a state can have its representation in the Senate diminished is by agreeing to it, only with the state's own consent. And no state's ever going to say that. No state's going to say, oh no, we have way too much influence already. Let's just give away some of our power. No, every state wants to hold on to its equal status in the Senate. So that's a Federalist measure. But then we get to Article 4, which in some ways is the kind of the key Federalist article. This is the article that lays down rules for the relations that states have with one another in the first place. Because to create a union of states, you have to do more than just put a national government on top of the states. You also have to bind the states together to some degree. So, for example, in Article 4, Section 1, you have the full faith and credit clause, which states, and I will read it so that you actually have the words. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. Right? And Congress can prescribe how exactly that's done. So what that means, this doesn't mean that states have to enforce one another's laws. That doesn't mean that, like the state of Texas has to enforce Oklahoma state laws or something like that. But it means that they have to respect the acts of various states. Let me give you a clear example from our federal system. Like probably most of you who are watching this have a driver's license. And the driver's license is issued by a particular state. So like in my case, I got my driver's license in the state of Washington. So it was the state of Washington that determined I was qualified to drive. But, I haven't lived in the state of Washington for over 20 years. But that license, that official act saying this person is eligible to drive, was accepted by Massachusetts when I lived in Massachusetts. It was accepted by Maryland when I lived in Maryland. It was accepted by Texas. And then I got a Texas driver's license. So when a state issues you a driver's license, that driver's license is good for the entire union. You can use that to show that you're eligible to drive, because the other states, like if you have a driver's license from the state of Texas, every other state has to accept that as making you eligible to drive. So in the same way, I was born in the state of Washington, which means my birth certificate's from there. I was married in the state of Florida, so my marriage license is issued by Florida. But Texas recognizes my marriage, even though the marriage license was given by Florida, and Texas acknowledges that I was born because it accepts the birth certificate issued by the state of Washington. So that's kind of like, full faith and credit in action. You can see why this is important, because it makes it possible for people to move from state to state without having to start completely over in all things. Obviously, this also would imply things like if you are charged with a crime and you flee to another state, that state has to recognize you're a wanted person, and if you're apprehended, return you to the state where you're to stand trial. So you can't just escape. You can't break the law in one state and get away with it by going over into another state. Section 2 has to do with privileges and immunities, and it says the following. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Now, it's controversial what exactly the privileges and immunities, what that refers to. One interpretation that seems plausible to me is that the privileges and immunities of citizenship are those kind of minimum rights that a citizen must have in order to be secure and free in society. So things like the right to go into business, the right to get a job, the right to travel from place to place. In some Supreme Court cases, it seems like the right to bear arms was included here, the right to publish, the right to associate, equal protection of the laws, and things like that. So this is a somewhat, this is a very controversial, I guess, interpretation nowadays. But this idea that basically, if you're from Texas and you go into Oklahoma, that doesn't mean that Oklahoma gets to treat you as a second-class citizen. You need to be subject to the same rules as Oklahoma natives when you go there, have all the same rights as citizens that they do. So that's part of building a more perfect union. And also, although I mentioned it in conjunction with Section 1, Section 2 is the place that mentions that states have a duty to return fugitive criminals to the states where they've been accused. Now, you also have here, and I'll be talking about this in a future lecture, the Fugitive Slave Clause in Article 4 on page 554, which says, "No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due." So that's a fugitive slave clause. Now, there's a little bit more to it than that, but basically what this means is that if a slave escapes into another state where, say, slavery is illegal, nonetheless, that state has a duty to to allow for the return of that slave to his or her master. How exactly this is done, it was a matter for Congress to decide. Congress passed particular laws to stipulate how the Fugitive Slave Clause would be enforced, right? Like, do you get to pursue an escaped slave and bring them back by force? Or is it the case that the state that they escaped into is responsible for apprehending and returning? There are all sorts of detail, that are distasteful to talk about. This was a necessary provision for getting the Constitution ratified because Southern states, even though slavery, I believe, was still legal in the northern states, it was so small and so marginal, and there was already anti-slavery sentiment growing, that Southern states would not have been willing to join a union where it was possible for their slaves to escape to the north, basically, and just be free. So they needed some kind of guarantee that escaped slaves would be returned. So that's what the Fugitive Slave Clause is there for. Although, again, the word slave is not mentioned. It's very much a circumlocution, because, as I'll talk about in a future lecture, they did not want the word slave to show up in the Constitution. Now, Sections 3 and 4 of Article 4 contain very important protections for the states. So Section 3 says, new states may be admitted by the Congress into this union. So in other words, Congress is the one, as the country has grown over time, right? Originally you had 13 states, then it grows over time. Now we've got 50. How does a new state join the union? Congress approves it. So Congress has the power to approve new states. But note this, somebody might say, well, wait, if Congress has the power to approve new states, doesn't that give Congress power over the existing states if, say, they wanted to make a new state by dividing up an existing state or carving off part of an existing state? Right? Giving Congress the power to approve new states might seem to give Congress the power to alter old states. And so to make sure that that is clearly not the case, it says, no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states or parts of states without the consent of the legislatures of the states concerned, as well as the Congress. So, although Congress has the power to admit new states and govern territories, no state once admitted can have its borders altered without its consent. And that is the key protection for federalism. That's what guarantees the existence of the lower level of government. That once a state has been admitted, the only way that state can be carved up or merged or done away with is through the consent of that state's own government. So, for example, North Dakota and South Dakota don't have a whole lot of people in them. So, Congress might say, hey, why don't we just merge these two into one state and we'll call it Dakota, right? Doesn't that make sense? But no. Not unless North Dakota and South Dakota both agree and Congress agrees to do that. But otherwise, states cannot be, taken out of existence against their will. So it's different at the state level, where like counties, the lower level of government in the states, counties do not have guaranteed existence. Counties can be designed and redesigned and merged and sliced and diced and whatever by their state governments. But the Constitution specifically safeguards the territorial integrity of every state in the Union once it has been admitted. Now, this Section 3 also talks about how Congress has the power to govern territories until they've been admitted as states. Section 4 gives you another important protection. It says, the United States shall guarantee to every state in this union a republican form of government. And by republican form of government, they mean representative government, government where power is ultimately derived by the consent of the people through a ratified constitution, and where you have, a legislative branch that is electorally accountable and all that kind of stuff. So no military coups. If there's some kind of like military coup or something like that in a state, the federal government is constitutionally obliged to reinstate representative democracy in those states, and shall protect each of them against invasion. So in other words, if a state is invaded, the federal government must come to its defense. And you can see why this might be kind of important. So, if a foreign nation invaded California, I think probably President Trump might hesitate in wanting to help California, because he might think, hey, they didn't vote for me. Who cares about them? Or, before President Trump, like if there had been a foreign invasion of Texas, I imagine President Obama probably would have thought, well, I mean, they didn't vote for me. Texas is a Republican state, so why should I help them? So this provision is basically there to make sure that all states are equally entitled to the protection of the federal government. That if a state is invaded, the federal government is constitutionally required to act, whether it likes it or not. And also on application of the legislature or of the executive, so the governor, when the legislature cannot be convened against domestic violence. So in other words, where domestic violence there means like domestic insurrection, violence and disorder and riots and stuff like that. So the state governments can call upon the federal government to come in and help restore order in their own state if they're in some kind of emergency situation or order is breaking down. So that's Article 4. That's the primary kind of Federalist article of the Constitution. So in the next lecture, I'm going to talk about Article 5, which has to do with how to amend the Constitution.